the trial against Illinois' gun ban, likely touching on a variety of other things that could impact the outcome of other cases, including a case challenging the ban on silencers in Illinois. Good morning, Illinois in Focus Daily. I'm Greg Bishop, and the headline at thecentersquare.com. Gun ban trial touches on banned features plaintiffs say facilitate self-defense. So I wanted to go through this a bit because sitting in the courtroom last week, as the gun ban challenge wrapped up on Thursday, was pretty revealing in some of the testimony. And of course, you can check out my Twitter page, my X page, Bishop on Air, for all of that rough transcript. We're not going to get the transcript in the trial until sometime in December, but wanted to definitely get the info out via X so that people could review that going forward. But a lot of the trial, of course, as we talked about last week, focused on the difference between civilian firearms and military firearms, with experts kind of clashing as to whether semi-automatic only should be just for military, as well as banning them from civilian use, with people coming at it from different approaches. But they also discussed a lot about features and the various features that are on these banned firearms. Everything from barrel shrouds to pistol grips to even flash suppressors. And the witnesses went into detail about what flash suppressors are used for, and in particular, they help move and direct the flash away from the individual's eyesight so that their eyesight's not blocked when they're firing in self-defense. That's what the plaintiff's witness said. But then the defense came back during some of the questioning and asked one of the plaintiff's witness, well, doesn't the flash suppressor also allow for an individual to better aim when they're in a dark movie theater? And that witness said, yeah, of course. But that question was posed to Dane Harrell. He is one of the lead plaintiffs in the consolidated cases, Harrell v. Raoul. And he shared some of his thoughts on what exactly that question means and where that question comes from.
That may be true. An unlawful use for a firearm that's commonly used by law-abiding citizens for lawful purposes can be used in a way that's egregious, in a way that's illegal. But for a homeowner or for a business owner or a private citizen that's trying to protect their life or their family's lives or those around them, then obviously there's utility in a benign or in a favorable way as well.
So Harrell again talking about how it really goes to the intent of somebody's heart that's pulling the trigger. Saying that, people do it for lawful purposes to protect their homes, themselves, their family, their business. But when it comes to that flash suppressor being used for ill intent, again, he says that it comes to the intent of the individual behind the trigger. But they also discussed a variety of the other various attachments that are banned, including silencers. And Judge Stephen McGlynn, in questioning one of the plaintiff's witnesses, talked about how a suppressor, a silencer, with the threaded barrel of a handgun or even a rifle, allows for better hearing. Now, the plaintiff's witness in this case, Randy Watt, he had hearing problems, and he started off by talking about how his line of work has led to his hearing loss. And he talked about how, in his case, of course, the silencer really helps him continue practicing shooting for self-defense purposes in practicing and training, because it silences the fire. But, the other side, they may say that helps a criminal with ill intent to conduct criminal acts. But the silencer issue, with Judge Stephen McGlynn raising the question and explicitly saying, doesn't that help the others in a house be able to hear commands from the person who's approaching and confronting home invaders? And the witness said yes. But that really caught the attention of Mark Smith from Four Boxes Diner. He shared some of his thoughts of Judge McGlynn discussing the silencers and the use of these silencers and the common use test and so on.
He's connecting the dots between suppressors. He's talking about the Supreme Court precedent, and he's talking about the in common use test. Why is a judge connecting those dots with a single witness? Well, anything's possible. We can all speculate as to what he's doing. Maybe I'm totally wrong, but if it were me and I were a betting man, which I actually think I am, but set that issue aside, guess what? I'm betting that Judge McGlynn has connected the dots and realizes that indeed suppressors facilitate armed self-defense, therefore they're arms, therefore the text is satisfied, therefore the in common use test applies, therefore the government bears the burden to show that something's not in common use.
So the silencer was another attachment that was discussed in court, but also there were conversations about collapsible stocks, and the plaintiff saying the collapsible stock on the butt of a rifle helps ensure that anybody of any stature is able to operate that firearm safely. Pistol grips allows for the firearm operator to better aim. The barrel shroud allows for the firearm to have safety features. And so the plaintiffs really laid out all of these features were safety features for the individual who is firing the firearm. But of course, these various features are banned by state's law in Illinois, and that's what's being challenged. So clearly a lot of back and forth here, especially in the gun ban challenge. In the gun ban challenge, they have until October 21st to file remaining briefs before McGlynn issues an order. Now, the silencer ban, that was actually transferred, one of the cases, from Judge McGlynn to Judge David Dugan in the Southern District, and then it was consolidated with similar cases, and that case is now known as Morse versus Raoul, and that case is still pending. Those consolidated cases and challenging the silencer ban in Illinois still pending. So clearly a lot more to be said about all of that here in the state of Illinois. Be sure to get the latest with Illinois in Focus Daily and the Center Square. Like, subscribe, hit that notification bell for America's Talking Network, and join us each and every weekday morning, giving you a rundown of things impacting the state of Illinois. We've got a lot to tackle, so be sure to stay with us each and every weekday morning here with America's Talking Network.